showcasing that specific knife in the shop window will made an offer for the buying party. With that, let's move on to the next one, Queen's Bench Division arguments, which was raised at High Court. There, the sole question was that whether this knife exhibited in the shop window with the price sticker behind it was an offer for sale within the meaning of Section 1 of the Restriction of Offensive Weapons Act 1959. There, what was highlighted was by the ordinary contract law, it was highlighted that this kind of action will be in invitation to treat. But they highlighted two specific cases where there can be contradiction with these concepts. So they highlighted first case as Keating versus Horwood, which was a case related to sales of food order raised in 1921. And then they highlighted a case which is Wills versus Madison case, which related to meat order raised in 1940. There, the prosecution party highlighted that there can be an offer made without we properly communicated it to the offerer. And they highlighted that if a person in 1960 come to that shop and ask whether they can, why is that specific knife is displayed in that shop, the answer should be that it is for sale. With that, we are going to move on to the defendant side arguments. For that, I'm going to invite Nirmali to highlight those arguments.
Thank you, Asana. Let's see the defendant side arguments. In order to form a contract law, there must be an offer and as well as the acceptance of that offer. For that, there are four possibilities. Let's take each one of them separately and discuss. Let's move to our right-hand side. The offer. Offer is the expression of willingness to contract. That means in our case, the shop owner has to say that I'm willing to sell my knife, and there must be someone that accepts the offer. That means, but this case was not happened, and we can reject this argument. On the other hand, the counter offer. The counter offer means someone has to come and say that I will buy you, as an example, I will buy you a knife with some discounted price or some deferred payments or something like that, and that counter offer has to be accepted by the shop owner. But this scenario also not happen, and we can reject the second argument as well. When we move to our left-hand side, the invitation to treat. That means an indication of a willingness to do a business, but this is not an offer. To be and come into a contract law, there must be an offer, and offer should be given by someone else. That means someone has to come and say that I will pay this much of sum for you, and that is the offer, and that offer has to accept by the shop owner. But this scenario also not happen at the case. So we can reject the third argument, and also the no one is buying the knife. That means obviously no contract, means fourth scenario also rejected. So because of all four these scenarios, we can reject, and there is no sufficient evidence for us to claim that the shop owner has any sales contract with someone else, anyone in the shop. So because of that, as per the law, the Restriction of Offensive Weapons 1959, we can claim that the defendant is not guilty for displaying fixed knife at the shop window. With that, I would like to invite Ms. Dulshika to discuss about judicial decisions.
Thank you, Ms. Nirmali. So now I will discuss about the judgment related to this case. So as discussed by Ms. Nirmali and Ms. Vasana, the initial judgment was given by the magistrate court. So the court is mainly concerned about the definitions given in the Weapons Act number 1959. So the Weapons Act is only concerned offer as a offense under this law. So displaying a certain knife with the price in front of a shop is concerned as an invitation to trade, which means seller is inviting certain buyer to negotiate the price related to that item. So the court is given the judgment based on the definitions adopted in the contract law. So the final decision was made that the defendant is not guilty for this offense as it is an invitation to offer. So moving to the post judgment. Initially, throughout this judgment, since this first judgment is not given by the majestic court, is not satisfied by the prosecutor, he was appealed again for the high court. So therefore, in high court also, the judgment was given based on the consideration contract law, as it is an invitation to treat. So it is all the final judgment also given as the defendant was not guilty for this offense. So moving to the post judgment, as we can see throughout this judgment scenario, we had identified there is a loophole in existing 1959 Act, Weapons Act. Therefore, immediately after the final judgment was given, existing 1959 Offensive Weapon Act was amended by inserting the word possession for purpose of sales or hire as an offense. So moving to the summary of this case, Fisher vs. Bell. Initially, the Fisher versus Bell case was highlighted the issue whether if any item is displayed in front of a shop which is listed with the price, whether it's an offer or a not, whether it's an offer or an invitation to treat. So both magistrate court as well as Queen's Bench Court, which is High Court, identify this as a invitation to offer under court contract law. Besides, the existing 1959 Weapons Act is not mentioned invitation to offer as a guilty. So the final judgment was given. Defendant was not guilty for the offense which he had been charged. So as a conclusion, most significant part of this act is once the final judgment was given by the court, immediately existing 1959 Weapons Act was amended by inserting the word expose or possessing a certain item in front of a shop with the purpose of buying as a offense under Amended Act 1961, Section 1(1). So with that, we conclude the discussion related to Fisher and Bell case. So thank you so much.
Sindhu was here. Are they not taking part in this? Then Danura. Yeah, that's fine. Thank you. That was a good presentation. Can you hear me now? Yeah, that was a good presentation. I think everybody else can also pick up some pointers on that. That was a very good presentation. And very important, the post-judgment analysis also, I'm glad that they did it, where they discussed what happened after the case, where they basically amended the law to say that even invitations to treat will be an offense now. Right, so that's good that that was analyzed. See, when you do cases like that, what happens is things we can't discuss in class gets discussed, so that's good. Great. Okay, so just FYI, so we are having one more presentation today, C1. Yeah, C1's there. D1 and C2 are next week, okay? D1, who's D1? D1, C2, C2. So somebody mentioned that B2, there's one person who has an issue next week, so we moved C2 up. C2, you're a B2, right? I can't hear you. With the problem is it's the C2 group. Okay, so we can have B2 then. D1 and B2. B2 is here. Okay, B2, I'll tell you the case as we go along today, right? And D1, I'll tell you the case today as we go along. Okay, so we're going to have a special session for about, I think, 15 groups or so. We are not going to be able to do during this lecture, so we'll have a special session. I'll let you know those dates, right? For those 15 groups, I will give you cases from across the lessons that we have done, just so that things are interesting. Okay, all right. Let me move this quickly. Yeah, that's fine. With you guys, I stopped after the 5th point. Is that correct? Or the 6th point? 5 or 6? 5, right? Thanks. Okay. So if you remember, we were talking about several points on contracts. We've talked about 5 points. That is, we talked about the definition, the agreement. We talked about consideration. We talked about form, and we finally talked about capacity and equity. Correct? Those 5 points we talked about. Point number 6, illegality. We're going to have to rush through some of this because we have another presentation also we have to cram in through to today's session, right? Illegality. Illegality is that a contract can be nullified on the basis that it is illegal, even though all the requirements are satisfied. That means it can have offer, it can have acceptance, it can have consideration, all of the requirements can be met, but it can still be illegal. You can't enter into contracts for illegal things and say that contract can be enforced. I can't enter into a contract to sell drugs, right? And then when I supply the drugs and somebody doesn't pay me for the drugs, I can't go to court and say you didn't pay me for my drugs. So that's a breach of contract. You can't do that because the law in Sri Lanka recognizes that's an offense. So therefore you are not allowed to come to court. So you can't contract on illegal substances, on illegal issues. You cannot enter into a contract. Now, obviously, this will change from country to country. No? What is illegal in Sri Lanka won't be illegal in other countries. A good example of this is the sale of marijuana, right? The sale of marijuana, hotly debated here also right now, right? Whether the sale of marijuana should be legalized in Sri Lanka. Now, at the moment, the result, a contract to buy or sell marijuana is illegal. But go to a different country, go to America, go to the Netherlands, that contract is very valid. Entering into a contract for the sale of marijuana is completely valid. Because why it's not illegal? So it varies from country to country what is illegal. But whatever is illegal in Sri Lanka, if you enter into a contract for the sale of goods or contract on services for the provision of services of illegal activities, it's not valid. That contract, even though it has all the requirements satisfied, will not be valid. So it can be illegal on 2 counts. It can be illegal because of statute. It can be illegal because of common law. Illegality can have 2 parts to this. The illegality can arise from contract. Sorry, it can arise out of a statute. Statute is an act passed in court in the parliament, or it can become illegal from common law. So it can become illegal from statute, means statute decides on certain things. A good example is maximum retail prices. Maximum retail prices have been decided by the parliament, right? Fixed prices for sale. Parliament or a delegated authority like the consumer affairs. They are also they are a quasi-judicial entity who is entitled. Quasi-judicial means kind of judicial, right? It's not essentially a court or a legislative body, but they have similar powers. We call it delegated legislation. Legislation, the right to legislate is with the parliament, no? But parliament can delegate that right to different people. So in some acts, you find that the act says that we authorize the Director General of so-and-so authority to make relevant regulations as and when necessary. That's why they issue gazettes. So those are laws, right? Therefore, these bodies can act as delegated legislators. Those are also legislation. So where something is illegal by way of legislation, it cannot be valid. Okay? Then so that's straightforward, because anything that they specifically provide for in statute only is illegal. Now the other problem, the bigger issue is illegal by common law. Illegal by common law means that a judge decides that something is illegal. So judges decide what is illegal on a case-by-case basis. So this is an evolving process. When you come before the courts decide that this is an illegal act. So this is based on a very famous principle in law, not so much commercial and business law that you all talk about, but based on public policy. We call this public policy. It is based on public policy that often they will recognize these things as illegal. Public policy is basically a discretionary right given to the courts. The courts to decide what is contrary to public policy, what is against public policy. Public policy has a general English definition. The policy that is applicable to the public. What is the pulse? What is the morality of the society? To give effect to that. In that society, even though something is not expressly statutorily illegal, it might be illegal because the public morality would see this as wrong. Right? Say, take a society where nudity is not an offense. Walking around naked is not an offense. Take a society like that. But if there is an issue like that, the courts can recognize that that is contrary to public policy. Walking around naked is contrary to public policy because the society's goals, society's objectives conflict with that act. Therefore, the courts will say that is contrary to public policy and they will prohibit you from doing it. So then when they prohibit you from doing it, it becomes illegal by way of law. So public policy, you will understand, is a very wide power the courts have. The courts have a lot of power in that. They can decide what is illegal, what is not illegal. That power is vested with them. So that it's public policy is often called in jurisprudence as an unruly horse, right? An unruly horse is an animal that can wreak havoc if allowed to go free. So the unruly horse, they say in law, must be very carefully controlled. So the judiciary must be very careful in exercising this power. They shouldn't be too generous in saying everything is contrary to public policy, because at the end of the day, they are the final deciders on what public policy is. No, so they can abuse it, but fortunately, we don't see judicial systems generally abusing this policy. But it can be illegal on the basis of public policy. If it is illegal, then the contract is not valid. Okay. So that's illegality by contract. There's one case you can, if you want, you are interested, you can have a look at. Everett versus Williams. Everett versus Williams is a case where two parties entered into a contract to commit a robbery. They said, you and I will rob a bank. You drive the car, I will sneak in and point the gun and get the money. Once we get the money, you drive the getaway car. Once we get away, we will split the money 50-50. Obviously, one guy didn't pay the other guy. Disagreement, although the contract was there. So then tried to go to court to enforce it. Idiot, no? Right? Court said, sorry, this contract we cannot enforce because it is an illegal contract. Okay? Clear? Not that complicated. Next point is reality of consent. Reality of consent. Yeah. We get the mics going. Can we send a mic? Oh. Let's say one mic on this side, one mic on that side. To make life easier. No?
So where do like says enemies of the state fall into? Is it
Yeah.
under incapacity, or
No, it would be illegal here. It would be a illegal contract.
that is the government has to declare an enemy of the state
Correct.
and you cannot enter?
If the government, so what her question is about enemies of state, if the state recognizes a particular country or an entity an enemy of state, entering into a contract with that party would be an illegal contract. Yeah, it would be an illegal contract. You could argue an issue of capacity, but it is not that. It is really illegality. Because it's not that they don't have capacity. No. They do have capacity. They satisfy the requirement of capacity. It's just they are made illegal by the state. The state says it is illegal. Right? You don't have to split hairs, but generally it is illegal. Okay, that's clear? That's a good question. Anything else?
So one question from my side.
Reality of consent. Reality of consent means that even though I consent, the consent I give might not be real. Because I may have been mistaken. Now let's take an example. I want to sell my car to you. No, not to anyone. To you, I put an advertisement. I want to sell my car. So you approach me and say, look, I want to buy the car. Now I'm a little, and now you want to pay cash. Okay, I'm a little concerned. I don't know if you're creditworthy. And your argument is this. So you are saying you will pay half now, and tomorrow the remaining half you will provide. You will bring the remaining half tomorrow. You will pay half now, and you will drive away with the car and bring the other half tomorrow. Right? Now, for me to agree to this arrangement, I have the freedom to arrange it. It might be a dangerous arrangement, but I have the freedom to agree if I wanted to. No problem. Now, in order to do that, I do a little background check. I get your name. I check your creditworthiness, whether you are a reputable person of society, right? That you won't run away with the car and not return, not pay me the rest of the money. I check with the bank, and your name comes out as quite creditworthy. So therefore, I agree. You pay me half. You take the car and go. What happens? You steal the car, and I go now I go looking for your name. By name, I go looking for you. Then I find that that name belongs to someone else. You were an imposter. You used somebody else's name. And what did you do? You misled me to believing that I was entering into a contract with X, when in fact I was entering into a contract with Y, an imposter, who didn't have a good creditworthiness, so on. So in such an event, I can argue that although, now technically I have consented to this contract because I met the person in face to face and I consented. I accepted, no problem. But the problem is I can argue that my consent is not real. The consent that I gave is not real. The consent that you provide must be real. If it is not real consent, right, valid consent, then the courts will recognize this contract as invalid. Right? So it can be, the consent must be real. It becomes unreal, or the consent becomes unreal for 4 reasons. Consent can become unreal for 4 reasons. Due to mistake, due to misrepresentation, due to duress, and due to undue influence. Due to a mistake, due to a misrepresentation, due to a duress, due to an undue influence. Because of any of these 4 reasons, my consent might not be real. Where my consent is not real, the contract is not valid. So I'll talk about these 4 in a minute. But before we go to that, there is another principle I want to talk about. This principle is the general principle that applies. There are exceptions to this general principle. There is a principle in law called caveat emptor. Some of you may have heard this. Caveat emptor. Caveat emptor says that the general principle of law is the buyer be aware. Caveat emptor means buyer be aware. So the obligation to make sure that you check on what you're contracting and to enter into that contract properly that obligation is with the buyer. Caveat emptor says the buyer must always be aware. Right? So the obligation is on the buyer to make sure he checks the facts and enters into the contract. He must be aware. If he's buying us goods, it's his obligation to inspect the goods, check it and buy it. You know, back in the day when you wanted to go to buy some groceries, you went to the local market, you touched and felt the goods, right? You check the rice, you check whatever you're buying, and then you bring it home. Once you bring it home, if the goods are not of good quality, you cannot sue the seller because of this principle. Why? Because the buyer must be aware. You inspected it, you checked everything, and you bought it. Your responsibility, your fault. Now, of course, caveat emptor has become less and less applicable today. It has become less and less applicable because more often than not, we are not able to inspect the goods. We are not able to check the veracity of the product we are buying. So in such an event, caveat emptor won't apply. And later on in today's lesson, I will talk about how certain laws have been passed to actually help the buyer, to protect the buyer. We call this under the Sale of Goods Act. The Sale of Goods Act is specifically there to protect the buyer. So, yeah. That's the thing. So, online buying is a good question. Now, with online buying, can the buyer be aware? There is a degree of being aware. Right? Say, for example, now, the mistake I often make, when I buy things online, I buy something online. I'm a bit of an impulse buyer when it comes to online buying. I buy something online, and what comes is drastically different to what I expected it to be. Right? Now, there are two possibilities. One is that the seller lied to me. In the description, in the image, he misled me. In such an event, caveat emptor won't apply because he has misled me. My consent is not real. Although I have consented, it's not real. So there, caveat emptor doesn't apply. But there is also the situation that everything is there, all the information is there. I just didn't read it. Now, often to me, what happens is I buy something expecting a particular thing to be a particular size. But when I get the product, it's this tiny little miniature thing. I don't know if anything happened to you guys. Right? It has happened to me multiple times. Where I buy something expecting it to be a largish device for the purpose I want. But when I get it, it's some miniature little thing. But when I go back and look at the description before I complain and throw a hissy fit with the online seller, I notice it says the dimensions are 5 centimeters by 5 centimeters. Crap, my fault. Nothing I can do about it. Right? So caveat emptor can apply that. So we'll have to see now. Caveat emptor cannot now apply 100% of the time. Because of the different natures of contract, like you very clearly said, online purchases. Because of that, caveat emptor cannot apply 100%. I'll talk about online purchases in a bit when we talk about sale of goods, very important area. Right? Online purchases, it becomes a very important area to talk about. But the general principle, that's why I said the general principle is caveat emptor, buyer be aware. But it is becoming less and less important in today's context. In today's context, the buyer is the vulnerable party. In today's context, very rarely can you say the buyer has the upper hand. Buyer is often the vulnerable party in today's context. But of course, if you go to a shop, you look at it, you touch and feel it, you check everything there is to check in it and buy it and bring it home, and then later realize, actually, it doesn't work. Right, you go and buy a fridge, you bring it home and it doesn't fit into the, slot that you have to put your fridge in. Your fault. You should have measured it and gone. Right, not the seller's fault, no. Seller has given you a good fridge. You went, you checked everything and you bought it. But when you came back and tried to fit it into your slot for the fridge, doesn't fit, too big. What do you do now? You're stuck with it. Nothing you can do because caveat emptor will apply. So it depends. The circumstances will matter. Right. Now, if caveat emptor doesn't apply, there are 4 situations under which when consent might not be real. One is mistakes, where the sale is made by way of a mistake. The mistake can be due to different reasons. right? The mistake can be different reasons. It can be a mistake as to the nature of the contract. It may be a mistake as to the identity of the person you're contracting with, or it might be a mistake as to the subject matter. It might be a mistake as to the nature of the contract, what type of contract you are entering into. You may make a mistake. You may make a mistake as to the person you are entering into the contract. You make a mistake with regard to the subject matter. It can happen all three. Now, sometimes you think you're signing a guarantee, but you're signing something else. Sometimes we do this, no? You know, a friend will come and say, will you please be a guarantor for my purchase or whatever, and you go without reading anything. Let's be honest, none of you read these, no? Right? You don't read it, you go and sign it. You think you're signing a guarantee, but what you don't know is you have signed something different. Right? If that happens, you can potentially argue that there is a mistake. There are cases for all of this, but I don't think you need it. Foster versus Mackinnon, right? Foster versus Mackinnon is a case. How do you write Mackinnon? K or no K? Yeah. Foster versus Mackinnon is a case where the person thought he was signing a bill of exchange, but he was signing a guarantee. Mistake. It's a genuine mistake. Right? Then the case that I told you of the car seller, right? That is Ingram versus Little. Ingram versus Little, that is a mistake as to the person you are entering into the contract with. Who are you contracting with? You make a mistake. You think you're entering into a contract with X, but you have entered into a contract with Y. Ingram versus Little. Exactly what I talked to you about. What happened there? Yeah. Sorry? Yeah, so that's the thing. So you will have to show it's a genuine mistake. Not you being reckless about it, but you will the burden will be on you to show that you are in fact prove that with evidence that it is a genuine mistake. Yeah. Often that genuine mistake, for it to arise, you will have to show that the other party didn't tell you all the relevant facts. That's usually how you prove that mistake. But it can be proved with other ways also. Then mistake as to the subject matter. So there's a case called Raffles versus Wichel House. These are not very important cases, okay? I'm just giving you anybody who wants complete. All of these cases are there. Raffles versus Wichel House. Right? In Raffles versus can't read this. Wichel House. Okay. Raffles versus Wichel House was a case where I wanted to sell you cotton that was in my ship. I said I'll sell you the cotton. You said okay, I'll buy the cotton, and we entered into a contract. But the problem was I had several ships in the port that is full of cotton. I was offering to sell you ship number A. You were offering to buy ship number B. Right? There would have been a difference in the cotton quantity, or the quality of it would have been different. So therefore, it makes a difference. So therefore, the consent was not there because the subject matter we didn't agree on. We made a mistake. I made a mistake on what I was selling. You made a mistake on what you were buying. So there is no reality of consent. So therefore, the contract is invalid. Can happen. Mistake. Okay. Now, the bigger and the more dangerous one is the second one. Misrepresentation. Misrepresentation. That means, and this is what happens more often, somebody will misrepresent to me the facts, and I enter into the contract on that misrepresented fact. Very close to mistake. But in mistake, often you will notice that it's innocent. Both parties, it is an innocent mistake. It's genuine mistake. Let's call it genuine. Right? But misrepresentation is where I make a statement to you that is untrue. misrepresentation. I made a misrepresentation. Based on that misrepresentation, we enter into a contract. The contract is invalid. I'll give you an example. Now, let's say you want to go. Any graphic designers? Yeah, graphic designers. Anyone? No. Okay. I can sound competent when I talk about graphic designing because nobody's a graphic designer, right? Because I don't know anything about it, right? So let's assume I'm a graphic designer who wants to buy a laptop. Now, in order to do my job, in order to do graphics designing, I need a very special type of computer. Computer that can handle a heavy workload. Processing power must be higher, right? If we had a graphics designer, we could ask the specifics, but I want that. Now I go to the shop. I go to the shop and I say, look, I'm no expert on computers, but this is my job. I need a computer that has a powerful processor, which is able to do intense graphic designing. So the seller tells you, this model, look at this model is perfect for you. It has the latest chip. And he tells the name, rambles off some digits, that is the name of the chip. And it is capable of handling any processing of graphics. Right? On his statement, on his assurance that this is in fact that that's a computer, I buy it and bring it home. And I try to use it for graphics design. But immediately I realize this computer cannot handle the workload that I'm trying to put to it. Now, obviously I have an option of damages, but I can also go on the fact that there was a misrepresentation and ask for the contract to be nullified, invalidated. Why? Because he has misrepresented the facts to me. He misrepresented. He told me something that is untrue. He lied to me, misrepresented the facts. He did not tell me the truth. And based on that statement, I made certain purchasing decisions. So therefore, because there's a misrepresentation, I can very clearly argue that the contract needs to be nullified. Misrepresentation can be innocent, reckless, or fraudulent. Can be any one of those three. It can be innocent, it can be reckless, or reckless we also call negligent, or fraudulent. Doesn't matter. Any misrepresentation. Innocent misrepresentation is where you genuinely don't know it, just make a statement. Innocent. Negligent misrepresentation or a reckless misrepresentation is you're not sure, but you don't bother to check. You are not sure whether this is the computer that can handle processing or whether this is the computer, but you don't bother to check. You say, this is the one. And generally, if you say anything with confidence, it sounds true, no? Right? So the person buys. Fraudulent is you know it's untrue and you still make that statement. Doesn't matter, in any case, the contract can be nullified on the basis of misrepresentation. Clear? Yeah. Can we pass this mic all the way back? Yeah.
How would the caveat emptor principle apply on this case?
If there is a misrepresentation, then caveat emptor does not apply.
But the buyer be aware.
Buyer can't be aware if buyer relies on the seller for this. Well, I don't know this. So if I ask the seller genuinely, now it's very different. If I, as a buyer who wants to buy a computer that is, a particular thing, I take a computer expert. And I ask the seller, look, can you point me to a computer that is graphics, can work graphics intensive work? Then I don't rely on the seller. I tell my friend, okay, please check whether this is able to do what I need. Now, in that instance, I have very clearly not relied on his representation. Then buyer be aware, apply. But in the first instance, I went and relied on his statement. So where there is a misrepresentation made and where I have to a degree at least relied on that, then the principle applies. There is no reality of consent. So that's why I said caveat emptor becomes very, very redundant in today's context. At the moment we talk about sale of goods, this becomes quite obvious. This principle is kind of in its dying phases. Answers your question? Yeah. Okay. Third
Sir,
one.
excuse me.
Yeah.
So if you were to rely on an expert's opinion,
Yeah.
you would have to first define his expertise, right? You would have to validate that to rely on that.
Well, you'll have to convince the courts will. So what will happen is the seller, the shop owner will come and say there, oh, he didn't rely on what I said. He relied on his expert. So if I have an expert that is not competent, that is my fault. You don't have to show that he's in fact an expert. It really depends on whether I relied on it. So if I didn't rely on the seller because I relied on someone else. Now say for example, I remember when I bought a car some time back, right? When I bought a second-hand car. I'm not an expert on cars, so I took my mechanic, the guy who repaired my car previously. I took him to have a look at the car. Now, he doesn't have qualifications or doesn't have a qualification that he's a professional. But the thing is, whatever the seller told me about the car, I didn't believe. I believe what my mechanic told me, right? So then in that instance, it's very difficult to say that I relied on that representation. Doesn't the quality of the person that I am relying on, the person I bring, the expert I bring is irrelevant. What matters is, do I rely on his representation? The seller. If I don't rely on the seller's representation, then the seller cannot be held responsible for it. So this is about the seller and you. Your relationship with the guy who's giving you professional advice, if he didn't do a proper job, that's a separate action. Now, if my mechanic did a poor job, or my friend who is a computer expert did a poor job, I may have a later action against him, but that has nothing to do with the contract. Contract is with me and the seller. Me and the seller's contract can be nullified only if I rely on his representation. Now, because I relied on my friend's computer knowledge, I can't now terminate my contract with the seller. So I am stuck with this computer that is useless. But I have a different action, an action against my friend potentially. Right? But that is not based on contract law. That is based on something we call tort law or delict law, which is the topic for next week. Right? I will talk about that in length. That is obligations we owe outside of contract, which is not based on contract. We have lots of obligations that we owe to people without a contract. So that relationship is what we'll have to explore this. But here about the contract, it's about whether a misrepresentation was made and did I rely on it. If I did rely on it, two requirements are met. Fine. Done. Answers your question. Okay. Anything else? Okay. Third one, duress. Duress. Duress is where you get someone to agree to or sign a contract using coercion by threatening him. Now that threat can be violence, can be economic, like a bribe also. Duress. Duress can be a violent coercion, like, pointing a gun at someone and saying, sign the contract. Or it can be a situation where I give you a bribe and force you to sign the contract. Both are duress. For duress, if I enter into a contract on the basis of duress, then the contract does not have the right consent. Look, if I have taken the bribe, then there's a separate action against me for bribes. Don't worry about that. For me taking a bribe, there's a separate issue. But the contract will not be valid. Let's say a company official takes the bribe and signs a contract. The company can always say this contract is not valid because the consent was achieved through duress. Then a separate action against the guy who took the bribe, that is separate. Right? But the contract will not be valid. Duress. That can happen. You point a gun at someone and say, sign this contract. Right? Or give him some money and make him sign the contract. Both of those situations qualify as duress. Duress means that your free will is not at play. You're not entering into the contract with your free will. You are entering into the contract because of other extraneous factors. Is that clear? Everybody's okay on that? The case for duress? No. There is. And then finally, undue influence. Undue influence. That means you have been unduly influenced. Undue influence often works when you have a special relationship with the other party, a relationship of trust. That is when we can be influenced. No, this is not to do with somebody paying you money or something. This is where somebody influences. Now, a good example of such a situation is you and your doctor have a, good, like a understanding, a trust. You trust your doctor. Doctor doesn't trust you, right? That is not the point. But you trust the doctor, no? So whatever pill that the doctor gives you, you will take, no? So that gives the doctor a sense of power. So undue influence is where someone uses that power they have to influence you to enter into a contract. When that happens, the contract is not valid because there was undue influence used. Undue influence. So it can happen employer-employee is another situation. Usually the employer has a degree of control and a degree of power over the employee. Therefore, there can be undue influence. Now, another good example of duress is an employer can tell duress, not undue influence. Is where an employer tells you won't get your promotion if you don't do this. Now, that kind of thing is duress. Right? Undue influence is where you are influenced into entering into a contract even though you don't really want to, or you may think it is the right thing to do, but because of somebody, the trust level you have on someone, you are allowed to be influenced. Is that clear? So in any one of these four situations can result in the consent to the contract not being valid. If there is no consent to the contract, then the contract is invalid. It is null and void. Null and void means it's invalid. It's not valid at all. Yeah. Can we pass the mic to her up front? That mic at the back. Can we pass it up?
So out of that example that you've mentioned on doctor's case, shouldn't it be standing on the professional advice?
Yeah. So where the advice is wrong, the professional advice is wrong, you can sue them not in contract law. There again, it might be something else like tort law. But what I'm saying is they use that advantage that they have to make you sign a contract. They use that the level of trust or level of control or whatever. Because of that they have a power over you. They use that power over you to make you enter into a contract. That is what I'm talking about. We are not talking about the doctor giving professional advice. If the doctor gives bad professional advice, we have a separate action for that. Next week. Hold off till next Sunday, I'll explain all of that. But this is a discussion about the contract. If somebody uses undue influence on you to make you sign a contract, then it can be invalid. Yeah. Like even a parent can have undue influence on a child. That can happen. Parent can unduly influence a child. It's no bribe. There's no bribe. There's no threat. It's just undue influence. You know what influence is? No? This is undue, not good influence. Very simple. Okay? Because of any of these factors, the contract, the reality of consent might not. Okay? Number 9, let me just erase this quickly. Number 9 is one of the most important points on contract law. Number 8, sorry. Number 8. Terms of the contract. Now, When all said and done, this is the most important one for you. After offer and acceptance and consideration, for you the most important one is terms. Everything, all obligations on your contract is here in the terms. So what qualifies as the terms of the contract? So the first thing is the terms of a contract can be in writing, can be oral. There is no problem. Because sometimes our contracts are completely oral. So the terms are also oral. Right? When you buy a loaf of bread, you don't sign a contract, no? Right? So therefore it's an oral contract. So the terms are oral. Sometimes you sign a contract. Where you sign a contract, the terms are in writing. Now, that doesn't mean that in a signed contract, you can't have oral terms. That also can happen. In addition to the signed contract, there can be oral terms. Very rare. That is a very rare occurrence. Usually, when you sign a document, the document will say, this is the final thing. All other negotiations we had before, all chats we had before are invalid. The final agreement is this document. So, very rarely will you be able to argue that in addition to this signed document, there are oral terms. But it can happen. Let's take that example of the computer again. Where I go to buy the computer and I tell this guy, look, I want a computer that can do graphics design. And he says, this is the computer that can do graphics design. Then, okay, I say, okay, I'll buy that. We go to the counter and we sign a contract and I buy the computer. Now, in that contract, it's a standard contract. That contract doesn't say that this computer is capable of graphics designing. It doesn't. It just says they are selling me a contract. They are selling me a computer. This is the price. This is the warranty. That's what it says. But this clause that this is capable of graphics designing could be argued to be a term of the contract, even though it is not on the written document. It could be argued. But the one thing that has to be satisfied, if you want to make this argument that there are terms to the contract which are not in the document, but are oral, those oral communications and terms must be before the contract was entered into. It can't be after the contract was entered into. You have to understand, after the contract is entered into, you can't enter into terms. There can't be terms that are entered into after the contract. The contract must, at the beginning of the contract, the terms must be decided. That's it. Oral or written. So the contract terms can be in writing, can be oral. Okay. The terms can also be, in addition to oral, it can also be implied. It can be expressed or implied. So it can be written, it can be oral, it can be expressed terms, it can be implied terms. Different categorization, right? First categorization, we said written terms versus oral terms. Now, there can also be terms that are expressed terms, there can be terms that are implied terms. What are expressed terms? Terms that you and I agree on, expressly agree on, that are part of the contract. Then there can be terms that are implied into your contract. Implied. Usually this it gets implied into the contract because of a statute. The best example of this is the Sale of Goods Ordinance in Sri Lanka. The Sale of Goods Ordinance in Sri Lanka very clearly imposes and implies certain terms into your contract. Even though it is not expressly discussed between you and the seller, right? The terms are implied. Sale of goods obviously will apply only to a sale of goods. The contract, the statute will only apply to sale of goods. But if you if you enter into a sale of goods, in addition to your express terms, there are some implied terms. I'll talk about one right now. Buying goods by way of description. Somebody describes the goods to you and you buy the goods based on that description. Happens, no? Online purchases is one of those where we buy goods on description, either an image or a certain description that is in text. We look at that and make the purchase, right? Now, an implied term to that contract provided under the Sale of Goods Act is that the goods must always correspond to the description. It must match the description. That's an implied term. It doesn't have to be in writing. It doesn't have to be agreed between us. It doesn't have to be expressed. We don't have to expressly discuss it. It is implied into the contract. Automatically, it becomes part of the contract. So if the goods don't match the description, you can always reject the goods on the basis that it did not satisfy an implied term. Very important. Implied terms versus express terms. I will explore the Sale of Goods Act after we finish contracts today. We will talk about a sale of goods a little bit, right? But this is just an example of implied terms. Express terms versus implied terms. You have express terms that are terms that you and the other party or expressly discuss. Implied terms are terms that are implied into that contract. Is that clear? So firstly, I said that the terms can either be in writing or it can be oral. But oral or writing, they are all express terms. You understand that? Whether you and the seller discuss it, put it in writing or discuss it orally, they are both expressed. No? It has been expressed between you and the seller. Implied terms are terms that you have never talked about, but are part of this contract. Yeah. Yeah. Okay, question is, if there is oral terms, how do you put oral terms in the case? Well, that is evidence. I think we talked about it last week because it's evidence, right? Evidence has to be proved. So it is up to you to prove that this oral term happened, that this guy told me this computer is able to do graphics processing. He told me. So it's your word against his. That unfortunately is the case. Unless you have some bystander who heard this, or you recorded it on your phone, or there is some CCTV footage, something like that. Oral evidence will have to be proved. If nothing else, it comes down to your word versus the seller's word. So the courts will have to determine whether those who's lying, and because when the seller says one thing and the buyer says something else, one of them is lying. No? So the judge's job is to find out who is lying. And remember, lying in court on the stand is a criminal offense. Very dangerous game to play, but people do it all the time. But judges are very capable of understanding. Experienced judges know exactly when a person is lying versus telling the truth. Even experienced lawyers who cross-examine the witness know when they are lying versus telling the truth. It's just one of those things that you learn, I think, right? They know when he evades the question, the judge knows this guy is lying. Now, I've seen senior lawyers do where they ask a particular, I don't know if I told you guys this or Monday group, I can't remember, I'll repeat myself. I've seen senior lawyers, when they start cross-examining a witness, they'll ask so where did you study? Or, what is your job? When did you get promoted? Then they'll ask you a very serious question. Then you give an answer. Then they go back to another casual conversation. 10 minutes, you have another conversation about, other issues. What is your role in the company? Or, la-di-da-di-da. All kinds of questions they ask. Then 10 minutes later, he'll ask that same important question he asked earlier. Again, very casually. When the witness is kind of mellowed and very comfortable, he'll ask it again. Right? And sometimes the witness gives a different answer to the answer he gave first. And immediately then he tells the judge, didn't I ask this question earlier? Did he not give a different answer? Moment you say that, the judge realizes this guy is lying, right? And then everything he says thereafter, the judge will ignore. Judge will not take him seriously at all. So I've seen this happen. I've seen this happen where they ask the same question 3-4 times. And then point out, in the first instance you said this, second instance you said this, now third instance you've gone back to your origin. Which is the truthful one. Then these guys get tongue-tied, don't know what to say, and they get caught. So it is that, of course, is the art of the game, right? So that's why lawyers, you pay the big bucks to get the senior lawyer, because they know exactly how to get this truth out, and the judge will know exactly when the guy is lying. I've seen judges also reprimand the witness and say, please answer the question. You're evading the question. Sometimes the lawyer keeps asking the question, this guy evades it. If you've been to court, sometimes you may have seen these things. He evades the question. He doesn't answer. He just gives a roundabout answer. We had this one person coming and giving evidence about whether they had outright purchased something. Every time we asked about it, he was from a government body. He was like, oh, our job is to promote this, promote that. He's not answering the question. 3 times after asking the question, he didn't answer. The judge said, you answer now or I put you inside. Right? That was the option. Because you can't play around when you're on the witness box. You're under oath to tell the truth and nothing but the truth. So if you get caught, problem. So to answer your question, that of course is a part of the litigation process. But they will check the veracity of that oral statement. Yeah. Okay. So terms can be express, can be oral. Right? Express as in it can be, we'll put it like this, can be in writing, can be oral, then can be express, can be implied. Then these terms, right, whether they be implied terms, express terms, written terms, oral terms, are also categorized into conditions and warranties. This is where things are very important. Conditions and warranties. The terms can be conditions or warranties. We recognize now if your contract has so many terms, we identify some terms as conditions, some terms as warranty. It doesn't say that it's a condition or a warranty, but we recognize them in law to understand them to be conditions of. What is a condition? A condition is a term that goes to the root of the transaction, a very important term that goes to the absolute root of the transaction. Very important term. Let's put it like that. A condition is a very important term. And and this is where it's important. If a condition is breached, then the contract can be cancelled or nullified. Terminated. Not nullified, terminated. Contract can be terminated. If a condition is breached, now let's say there is a contract for sale of something. I buy something from you. Then the condition is that I pay you money is a condition. You give me the goods is a condition. Those two are conditions. The absolute root of this contract. Those are conditions. Now, if I don't pay you, you have the right to terminate the contract because I have breached the condition. Is that clear? A warranty then, on the other hand, is a not so important term of that contract. That doesn't go to the root. Basically, the contract can continue even without the condition, even if that warranty is breached. Warranty doesn't necessarily automatically allow you the right to terminate a contract. Warranty doesn't allow you to automatically terminate a contract. Condition allows you to terminate a contract. Breach of a condition. A breach of a warranty doesn't allow you to terminate a contract. Warranties are terms that are not so important. I'll give you an example of this issue arising. We, some time ago, Dr. Cabral's client, I was involved in the case. We had a case and it came up in the consumer affairs initially. What happened was this guy bought a car. He bought a Mercedes-Benz, right, for himself. And obviously when Mercedes-Benz sells a car, they give you a warranty. They say, hey, look, a warranty is that the warranty in this instance was that we will service the car for 2 years. We will provide you any repairs free of charge for 2 years. Those are things we allow. Now, okay, so those are there. Now, then what happened is the guy took the car for 6 weeks or 7 weeks later. I can't remember the exact car. 6 or 7 weeks later, the car broke down. I think it wouldn't start. So he called our hotline. I keep saying us because I was involved on behalf of Demo, right? He called Demos and said, look, my car has broken down. So Demo sent the vehicle, the truck to take the car. They took it to the workshop to fix it. But when they took it to the workshop and they tried, now you have to simulate the mistake now for it to, kind of restart this issue. Then they tried to start the car started. No problem. They can't fix the problem because they can't see what the problem is. So they tried it several times, kept it for a day, tried it again, it worked. They said, okay, you can pick up the car, seems to have sorted itself out. Second time, it happened again. 2 weeks later, it happened again. Wouldn't start. He called. When he called, they said, okay, we'll send the truck to pick it up. But before the truck came, the car started and he went home. Third time, 3 months later, it happened again. Wouldn't start again. So he called and we brought the vehicle back to the workshop. And at the workshop, it was tested. And now we identified, because the car wouldn't start even at the workshop. And we identified the problem. And we fixed it. We called him and said, okay, 2 days later, we called him and said, the vehicle's ready, come and pick it up. Right, done. He said, no, I don't want the vehicle back. Give me my original purchase price back. What was he doing? He was arguing that a condition of this contract has been breached, and therefore the contract is null and void. Right? That was it he was arguing. He was saying the conditions of this contract have been breached, so I don't want the car, give me the money back. He refused to give the money back. Now, I think demos at that point, several things. They said, look, if it breaks again, we will fix it. We can give you a guarantee it won't break like that again. This problem won't arise. We have now fixed it. They explained why it couldn't be fixed in the first instance. All that was done. Now, his explanation was, his position was, look, it broke down 3 times. What's to stop it from breaking again? Now, the argument that demo made was, look, we can confidently say we fixed it this time. The earlier instances, we couldn't fix it. All that was said. And demos even said, okay, we will extend your warranty for another 3 years. Well, he was getting a pretty good deal, right? So from the date that you pick up the vehicle, we'll give you, instead of 2 years, we'll give you 3 years warranty. Yeah. He said no. We refuse to pay, stand still. He goes to the Consumer Affairs to enforce this. Right? He goes to the Consumer Affairs. Consumer Affairs, there's a whole argument process, and the Consumer Affairs says, yes, we have to return the car's money to him. We have to pay him back the full money. There's a breach of condition. We refuse to accept the order of the Consumer Affairs. So from the Consumer Affairs, you can appeal to the Court of Appeal in Sri Lanka. So we filed an appeal in the Court of Appeal. Then the Consumer Affairs filed a case against us in the Magistrate Court, because Consumer Affairs had given an order and we were not paying. So they went to the Magistrate Court. That is where they have to go to enforce. They went to the Magistrate Court to get us to pay the money. We went to the Court of Appeal saying this order is bad, so we have to cancel it. Right? And then in the middle of this, that guy, the guy who bought the car, went and filed a case in the Commercial High Court. Right? So we were now fighting on 3 fronts. Consumer Affairs case had finished, 3 fronts. Now this argument was going on. Now this entire time, Demos is offering them, look, we'll do this, we'll do that, but we can't give you the original purchase price. I think at one point, Demos even said, we will pay you market value for it at price. We can't buy it back the original price because you have used it. It's a used vehicle. We can't, sell it. So, but we'll buy it at market value. I think initially he had bought it at like 20 million. I think they offered 17 or 18 something. Right? And then obviously, as this I think process went on for about a year and a half. Right? During this case, year and a half, that figure kept coming down. Why? Because the vehicle is just sitting in a workshop now. Right? So 16, 15, so on and so forth. In every court, what was being debated? Whether the condition was breached or not. Whether it was a condition or simply a warranty. Of course, we made a lot of other arguments. We made several arguments. One was that they didn't sue the seller. They have only sued Demo. Demo wasn't the seller of the car. Seller of the car is the Daimler company in Germany. They should have brought them also as a party. We are only there to do the service. The contract is with Daimler. So the product is Daimler. So we made those arguments also in the process. Makes your life very difficult when you make lots of defenses. The other side's job is very difficult because you have to keep batting them away, right? So finally, I think 1.5 years later, and so much litigation costs, the guy decided to settle. And I think he paid 14 million ultimately. If he had taken the original deal, he would have gotten 18 million. If not, he would have gotten almost a brand new car with an extended warranty. Refused, he took a bad deal at the end of the day, but essentially settled. Right? It also kind of stands to show you how the litigation process can sometimes be frustrating. But yeah, this case is a good example of the difference between conditions and warranties. If it was a warranty and the Consumer Affairs, they determined it was a condition. That is why they said You have to pay. But you have to understand the consumer affairs will never give an order against the consumer. Very rarely have I seen an order being given. Anybody from the consumer affairs? No. Consumer affairs will very rarely give an order against the consumer. So we knew this order was going against us anyway, right? So they said it was a breach of a condition, but our argument was it wasn't. So it was a debate. So the entire litigation revolved around the term. What was the term that was breached? Right? So it's a good example of that. Unfortunately, got settled, so there was no final judgment. I can't give you a case that you can refer to. There is no, it was settled, right? So there is no final outcome. So when he settled, he withdrew all his cases, right? He settled in the Court of Appeal, withdrew his magistrate court case, withdrew the commercial high court case, and it was the end of that, right? Anyway, so terms, right? So the term, understand whether it's an oral or a written term, whether it's an express or an implied term, and most importantly, whether it's a condition or a warrant. Okay. The difference between conditions and warranties, you can have a look at the case of Wallis versus Pratt. Facts are not very important. Just it gives you the definition of what a condition is and what the definition of a warranty. It gives you a definition. What a condition is, what a warranty is. Now, last thing I want to talk about in terms is exemption clauses. Exemption clauses are a type of term that you put in your contract. Exemption clauses are a type of term that you put in your contract. Exemption clauses, what they do is they try to exclude liability. Parties will say, hey, put an exemption clause saying, I am not liable hereafter. So you may have seen this when you drive into a car park. At the place you pull into the car park, right outside, there's a big notice. What does the notice say? We shall not be responsible for any damage to the vehicle caused inside our premises. You read that and you still put into the car park. That is an exemption clause. They are excluding liability. They are saying we are not liable if something goes wrong. Please don't hold us responsible. Right? Exemption clauses. Now, the thing with exemption clauses is the courts are very reluctant to allow these exemption clauses. They are not very happy with it. Because that is one side saying we are not responsible. A clause that is saying we are not taking responsibility for our action. So the courts are not very happy with it. So they have interpreted it quite restrictively, narrowly. The exemption clauses, as much as possible, they narrowly interpret it. Right? So when you are crafting an exemption clause, it's not that the exemption clause can't be valid. But you have to be very specific with your exemption clause. If not, the courts will say this is not a valid exemption clause. They are very negative towards exemption clauses. So unless you put a very clear one, I can't remember the case, but I'll tell you a facts of a case. I can't remember the name of the case. This was a case on an airline. It said any passenger who is injured as a result of standing, any passenger who suffers injury as a result or while standing or something like that shall not be the responsibility of the airline. If you suffer an injury while you are standing on the airplane, you are not responsible. Now, obviously, that is to say what they meant there. What did they mean there? That means please wear your seat belt at all times. If you don't wear your seat belt, we are not responsible. Even if the light is off, wear the seat belt. That's what they're saying. So what happened was this person was on their seat without wearing their seat belt, but seated, suffered an injury. Airline said we are not responsible. Look, the clause very clearly says. Court said no. Look at the word. We will interpret it as narrowly as possible. What does it say? When you are standing, was this person standing? No. So you are responsible. You can't rely on the exemption. You have to take responsibility. Right now, any rational person will understand the objective of that clause to say that if you don't wear your seatbelt, we are not responsible. But then they should have very specifically put it. The fact that they didn't, that they were ambiguous in their term, and that the term was not. Then also there is an act. Unfair Contract Terms Act of 1997. Unfair Contract Terms Act, we call it ACTA in law, right? Unfair Contract Terms Act 1997. In the Unfair Contract Terms Act 1997, it says some types of exemption clauses are not valid. Like the most famous one that is not valid, I'll tell you. Where you are carrying out a commercial activity, the Act says that where you are carrying out a commercial activity, you cannot exclude liability for death or personal injury. If you are a business, you can't have an exclusion clause saying that we are not responsible for a person's death or personal injury. So at a shop entrance, you put a notice that says any injury you suffer that during inside the shop, we are not responsible, is not a valid clause. It's an exemption clause, correct? But ACTA says it won't be enforceable. It's not a valid exemption clause. Because any commercial party cannot exclude liability for death or personal injury. You can't. You can say it's standing on your head. Doesn't matter. ACTA says not valid. We're not going to give it. Okay. So ACTA again is very so you understand this is we are trying to protect the innocent party, right? Unfair, exemption clauses or exclusion clauses are a little unfair on one part. So we don't. The courts and statute have been very reluctant to allow them to rely on that. They can. It is technically valid, but narrowly interpreted. There's a famous case, Ollie versus Marlborough Court. Can't spell Marlborough Court. I think Ollie versus Marlborough Court. Group B2. B2 is next week, no? I said this is your case. Ollie versus Marlborough Court is your case. Okay. What happened in Ollie versus Marlborough Court? So this lady checked into a hotel. She went to the hotel. She checked in, paid, went into her room. And when she went into her room, then she wanted to come out to get some food. Right? As she was coming out, in fact, I think I can't remember if she came to take food or anything, but she essentially wanted to go out. Right? When she was going out, she noticed the notice at the back of the door, which said, we don't take any responsibility of for any loss of possession that happens inside this room. That you're responsible for your goods inside this room. We are not responsible as a hotel. She saw it, she read it, but she went. When she came back, her luggage was missing. Property was missing. So she sued. Hotel argued that there's an exemption clause. We have excluded liability. Court said the exemption clause was not valid. Why was it not valid? Because that cannot form part of a term of the contract. This term was made known to us only when we went into the hotel room. But the contract was entered into at the lobby. So if there is a term, especially an exemption clause, where should it be displayed? At the lobby before I enter into the contract. You can't input a term of the contract, especially an exemption clause, after the contract has been entered into. So Marlborough Court says, you still remain responsible. Exemption clause is clear? Everyone follows that? Right, so terms, very important part of contract law. Now, any issues, any questions? Because we've covered like one of the most important areas. Anybody got any questions on the terms issue, especially? Anyone? Okay. Next, number 9, termination. When can a contract be terminated? Now we have talked about the birth of the contract, right? All of that. Now we're talking about the death of the contract. When does the contract end? Right? Contract can end for a multitude of reasons. The most obvious one is the obligations under the contract are performed. In other words, performance. When the obligations under the contract are performed, the contract can be terminated. No. When both parties have done what they are supposed to do under the contract, contract can be terminated. No need to have a contract. Contract is over. Termination happens by way of performance. That is the most obvious one. Second one, so performance is one way of terminating the contract. Second way you can terminate a contract is by agreement. Both parties agree that we are going to terminate the contract. Mutually agree. Not an issue. You agree. And if the parties agree, they can do anything, including terminate the contract. Right? Sometimes, of course, contract terms will remove that clause. Right? Some contracts, some parties, if they don't want the contract to be terminated, will take that part of clause out. That it can be terminated mutually or terminated with notice. You take that out sometimes. I've seen that happen. Even if such a clause is not there, if both parties agree to terminate, you can do that. Even if there is no term that says parties can negotiate and terminate, even if there is no express term like that, if the parties wanted to, they can negotiate and terminate. That's okay. Not a problem. So termination can happen because of performance, because of agreement. Then it can also be terminated because of breach. The contract is breached. Now we already know when can it be terminated because of breach? When the condition is breached. When there is breach of the contract, also you can terminate the contract. Often when there's a breach of contract, you can either terminate if the other party accepts, great. If they don't accept, you may have to go to court and say, look, the other party has breached the contract, so can I terminate the contract? Right? So you may have to do that. But if the party accepts, okay, we have breached, you can terminate, that can be the end of that. But if they dispute it, then you have to go to court and you have to convince the court that the other party has breached, therefore you have to be allowed to terminate. So performance, agreement, breach, right? Then number 4, operation of law. Because of a legal issue or because under the operation of the law, the contract can be terminated. Best example of that is one of the parties goes insolvent. You know what insolvency is? Go bankrupt. If one of the parties goes bankrupt and the court says the party has gone bankrupt, then the contract can be terminated on the basis of an operation of the law. Because the party has gone bankrupt, the contract stands terminated. Okay? So 4 very straightforward issues. And the 5th one under which a contract can be terminated is frustration. Frustration can terminate a contract. Frustration, effectively the same meaning you have in your head when you say frustration. The contract becomes unperformable due to some fact that is beyond the control of both parties. That's what's important. The contract becomes unperformable due to a fact that is outside the control of both parties. We'll take an example, okay? Now, there was a case where the King of England was to have a coronation, some celebration. Coronation celebration, and during this coronation celebration, he gets on a ship in on the River Thames, and he goes along the River Thames waving at every Tom, Dick, and Harry on the side. Right? Now, during this time, lots of people buy hotel rooms and even houses rent out rooms in their house along the River Thames. Why? Because everybody wants to see the king. So they sell. So months in advance, these rooms are booked. But closer to the coronation, the king became sick and cancelled the coronation parade. Then people who bought these hotel rooms wanted to cancel their contract. When the other party refused, they went to court. Court said contracts to terminated because of frustration. Why? Because of a fact that is beyond the control of both parties, the contract is unperformable. It doesn't make sense to perform. Now, with regard to frustration, you will know a specific word. Force majeure clauses. Have you all heard of force majeure clauses? You all would have seen it. And during COVID, anybody who is doing business would have come across force majeure clauses a lot. It was the forefront of discussion. Force majeure clauses is, we also call it act of God clauses. In all most contracts now, commercial contracts, you put an act of God clause. What does this act of God clause say? That if there is some event, that is what we call a force majeure event, then your obligations under the contract are suspended until this event occurs and will recommence once the contract, once the force majeure event ends. But if it doesn't end and you cannot, and it continues to be a problem, the contract can be terminated on frustration. Sometimes the force majeure event is 1 day. So then the contract is frustrated for 1 day or suspended for 1 day. Then after that you can continue. But sometimes the force majeure event goes on forever. Then the contract can be terminated for frustration. COVID-19 was an argument a lot of people made during COVID-19 when it initially happened. Now COVID-19 won't qualify as a force majeure. But back in the day, when first time it happened in March, when governments across the world locked down their country, because of acts beyond the control of the parties, the contract becomes unperformable. So in that event, force majeure event, your obligations are either suspended or terminated. Can happen. So act of God can include floods, earthquakes, things like that. That's why I call act of God clauses. Or it could be riots. It could be government actions. Right? Say, for example, when the government imposes curfew, randomly the government decides to put curfew. Then what happens? You can't carry out your business. Your obligations under the business are suspended until the curfew is there. If the curfew goes on forever, like during the first COVID pandemic, we had about 2-3 months, I think, right? Then the contract can be terminated. So force majeure doesn't automatically result in frustration and termination. If the act of God or force majeure event is a small, limited time event, for that period of time, the term is suspended. But if it goes on for a long time, then the contract can be terminated. I remember at that time I was working for this apparel company. I was doing consultancy, and they had these lots of contracts where they have very tight deadlines. Anybody in the apparel industry will know that they have tight deadlines to ship their goods. But because of the COVID-19 pandemic, there were delays. Right? You couldn't get employees to come to work. And the government mandated that the entire factory had to shut down if one person got COVID. There were lots of problems. So when those things happen, force majeure becomes the application. Now, until that happened, a lot of people thought this term force majeure that lawyers put in was a useless term. Right? People accuse lawyers all the time of overcomplicating contracts. Why are you putting these unnecessary clauses? They're never going to happen. Right? I've had this accusation made. Right? Why are you putting all these unnecessary complicated terms? Then other party doesn't want to sign. They are scared of the contract when they see the contract is so many pages. I've heard all this. Right? Until something goes wrong. When something goes wrong, they come running to you and say, how can we get out of this? Right? Can we get out of this? Right? What can we do? Then that is why we have those clauses in place. Force majeure clause is a very important clause to have it. Because you don't know what can happen. In 2000, it was COVID-19. Next year, it can be something else. Now, 2019, it was COVID-19. Sorry, 20, it was COVID-19. In 2019, curfew because of Easter tax. Right? In 2020, because of the current ongoing protests. What is going to happen next year? We'll have alien invasion at this point in Sri Lanka. That's the only logical explanation. Next thing that's going to happen. Right? So you need to have a force majeure for it because you can't predict these. No? They're not predictable. So in that event, force majeure allows you to, one, suspend your obligations. Number two, even to terminate. So the case that I talked to you about, the one about the king's coronation, is Krell versus Henry. Important case. D2 and D1. What is, where's D1? This can be okay. Okay.
Sir,
All right. So 5 reasons basically that we can recognize there can be termination. Now, on top of these 5, there can also be other ways you can terminate if the terms of the contract say you can terminate because of those reasons. You can, the parties can agree on the terms that you can terminate because of this reason. That's individual, that is bespoke, unique to each case, right? Lastly, remedy.
excuse me, sir.
Yeah.
Sir, Sukit here. I have a question regarding the force majeure clause and the contract start date. Is there a necessity that the contract is started before the force majeure incident occurs,
Yeah,
or
yeah,
is it
correct.
something like?
That's a good question. So what it is asking is, does the contract need to be concluded before the force majeure? See, once COVID-19 starts, you can't say COVID-19 is an act of God. Why? Because COVID-19 is now predictable, foreseeable. It doesn't become because act of God is an unforeseeable thing. For it to be unforeseeable, it has to happen after the contract is finalized. Right after now, for example, given this economic crisis and all these problems we are having, LCs can't be open, so on and so forth. In that event, you enter into a contract, and then one fine day, 2 weeks later, you can't open a LC, and you say there's a force majeure, so I can't open a LC. That is not going to be valid because you very well knew this was a problem you had. It has to be unforeseeable. If it isn't, then that doesn't apply. So, it answers your question.
Yes, sir. Thank you. Thank you very much.
Can we see what the chat questions are? The chat questions. So
there's one more question.
yeah, go ahead.
Even if the force majeure clause is not there, can't you argue that it's frustrated?
You can argue. Even if there is no force majeure clause, you can argue frustration. But if you have a force majeure clause, it becomes much easier. You don't have to go to court. Because if not, you may have to go to court. If you have a force majeure clause, then the parties can agree that this is force majeure and terminate the contract.
Right.
Yeah. Dylan says, is it possible that at the time of entering into the contract signing, it was legal? Yeah, it can happen, Dylan, where the contract was legal at the time of entering, but illegal subsequently. Then the contract is still illegal. Yes, that's a valid point. Okay? Right. Last point is remedies. Remedies to the contract. Now, let's assume that the contract has been breached. What are the remedies that you have? If the contract has been breached, what are the remedies you have? Now, where there has been a breach of a contract, you can go to court. The innocent party can go to court, right? The innocent party, the person who didn't breach it, can go to court and do a lot of things. Firstly, the innocent party can go to court and ask for a declaration allowing him not to perform the contract. His obligations, he can say, I don't want to perform my obligations because the other guy has breached. Right? That is the first thing. Number 2, he can ask for damages. Now in Sri Lanka, it's actual damages, not damages to as a punishment to the other side, not exemplary damages. That is, you don't ask for damages to teach the other guy a lesson. You ask for damages to compensate for what loss you have suffered. That's the only thing in Sri Lanka you are allowed to get. Okay? So you can ask for a declaration to not perform and damages, actual loss, right? Actual loss is very important to understand. We have a case that Dr. Cabral was doing, where the courts finally said we win. The case was given in our favor. That means we won, and the other party was guilty. But the courts didn't give us damages. We asked, I think, some millions of damages. Court said no damages, because the courts felt we didn't suffer actual damage. That look, there is a breach of the contract, therefore the other party is liable. But we didn't suffer loss, so no damage. So now we are in the Supreme Court challenging them. Although we won the case, we are in court, Supreme Court. We are appealed because we don't want just a piece of paper that say we won. We want damages. So we are now in the Supreme Court arguing that we did suffer a loss. So the obligation is on us to show that we have suffered loss. The courts felt that we didn't do a very good job showing that we have suffered loss. Right? Actual loss, the court said we didn't show that we suffered loss. Yeah. Where's the mic? Is the mic around? Are there different types of damage, as as opposed to money, is it? No, as I understand, it is money, but the way you quantify and the way you determine the amount can change. There are different ways. But I think damages are primary. What do you have in mind when you say something other than money? It's not on. Just so the other guys can hear on the group. Yeah.
So like you said, I think your claim for the damages was rejected.
Yeah.
So like, what was the situation there basically? Like in terms of the money, like how much did you like basically So to give you the facts of my situation, this was an intellectual property case, so I won't go into the facts of this because intellectual property was still not learned. When Sir talks about it, he'll talk about it. In this case, we said because our songs were used by somebody else and they made money out of it, we suffered loss. The other ones who would be able to sell our music, we weren't able to sell it because somebody else sold it. So we suffered X million of loss. But the courts felt that we didn't suffer X million. So therefore they said, we win the case. Yes, they did violate your rights by selling your music, but you didn't suffer any loss. Now we don't agree with that in court because of that. We're in the Supreme Court because of that, but courts can sometimes do that where they feel like you haven't suffered loss. Yeah? Yeah. Can I pass the mic back?
If you are not the victim or the affected party, how do you enforce a limitation on the damages?
If you are not the victim or the...
If you are not the victim or the innocent party here, how do you limit or enforce the limitations on damages? Like there could be no enter damage. I could even say that caused mental damage to me and I could go to that extent, right?
You, in whatever way, you have to prove it. If you're saying you have suffered mental damage and let's say you had a mental breakdown because of that, you still have to go and show, look, because of the mental breakdown I had to go and see doctors, I had to get therapy, I had to do this, I had to do that. I lost my job. All of that is loss. You have to prove it. I couldn't do my job, so I was getting X amount from my job, so I need to be able to get that money back. I was not able to work for 1 year. I had to go and get therapy. I had to get an operation. Now next week we'll talk about tort, where this happens all the time, right? Those things are the loss that you have suffered as the victim or the innocent party. You have to prove, and it is the obligation of the other side to break it down. The other party will say, no, you didn't suffer all that. It's again one of those things where the parties will have to debate. So sometimes instead of us saying we suffered X amount, we can't sometimes quantify it. Sometimes what happens is we say, look, account for profits. That means whatever profits the other party earned, that is the loss we suffered. So we had a case where somebody was selling books in the name of Atlasy. You know Atlas books, no? They put I at the end, very similar looking book, and they started selling. They're pretending to be Atlas and selling. So people go and buy an book. It looks like Atlas. You bring it. You don't really think about it, no? Right? But actually what you have sold is Atlas. So Atlas argued, look, our loss is the profits they earned. So tell them to provide their profits. That will tell you the actual loss we suffered. It's difficult for us to quantify and say what the loss we suffered was. But our loss is their gain. So that also is a way that can happen. Right? So damage is quantified in a lot of different ways. You either show your actual loss or you ask the other party to account for profits. So
declaration, damages, specific performance. Specific performance is where you go to court and say, I don't want damages. I don't want anything. I want the other party to specifically perform their obligation. I want them to carry out their contract. I don't want them to breach their contract. I want them to perform their contract. Specific performance. Ask them to specifically perform their contract. Specific performance. It's another remedy. Very powerful remedy you can ask. You can also ask for injunctions. Injunctions are essentially you ask the courts to either get the other party to do something or to prevent them from doing something. Injunctions can be where you ask the courts to prevent a person from doing something and or to do something. It can be either way. Injunction. I'll give you an example. Now, before I give you this example, I'll give you a little context. Injunctions, there are two different types of injunctions in law. Very important for you to know. There are final injunctions. Final injunctions are given by the judge at the end of the case. That means when the final judgment is given, the judge will say injunction. Injunction is they can never sell this product ever again. That's an injunction. Let's say somebody was wrongfully using my trademark and selling sunlight, right? Sunlight goes to court. The final injunction they want to stop the other person from selling sunlight soap. So the final injunction is they can't sell sunlight soap. Final injunction. So that is valid from the date of the judgment forever. The other party cannot sell soap under the name of sunlight. Then there are interim injunctions. Final injunctions, there are interim injunctions. Interim is during the course of the trial. Sometimes you have to understand in court, you take a couple of years for a case to be fully heard. Now, by that time, the damage is done. Sometimes the damage, let's say a counterfeit product comes into the market. If you wait till the end of the case for the judgment and an injunction, then by then your market value has dropped now. Because the counterfeit has been in the market for 2 years. You want the counterfeit out of the market as fast as possible. So you ask for an interim injunction. That means you go to court and immediately ask the court until the case is heard and finished, give a interim injunction. So that interim injunction is valid from the point that it's given until the judgment date. At the judgment date, it will be made into a final injunction or they'll cancel the injunction. So an interim injunction is given on the face evidence. On the face of it, the courts will decide, on the face of it, does it look like there's a violation? Interim injunctions. Interim injunctions can be make it or break it for companies. Sometimes companies have to shut down. When an interim injunction, wait, they can't do business until the case is heard and finished. So, so then there's one more component called enjoining order. I'll explain this in the course of this case. Right now, we did a case where one party came to us and said, look, there has been what is referred to as an enjoining order gotten against us. An enjoining order is where one party will go to court and get an order against another party without that party even being there. That means one party runs to court alone, by themselves, without the other party being there to defend themselves, and tells the court, look, all of this is happening, so give us an enjoining order. So what this company did was they went to court and said, look, so let's say X went to court and told the courts, look, Y is selling T, right, in a package that looks identical to our package. Right? They are selling it on the identical package. Now, every day we are losing millions because they are selling the tea as if it looks like our tea. X is selling, same. So on the basis, the court is satisfied and the courts gives an enjoining order preventing. Enjoining orders are given for short periods of time, maximum of 14 days, I think. Right? within the 14 days, the other party has to come to court and defend themselves, right? The court gives an enjoining order in favor of X to stop us from selling T, from Y from selling T. So Y comes to court, and the court now when both parties come together, then the next step is the enjoining order either is cancelled or confirmed by way of an interim. Interim is in the interim of the judgment you give an order, but that interim order where both parties make their case, they both tell court. Enjoining order is one party tells us. You understand when only one party gives evidence, it's one-sided. No? When both parties come, we have a better chance to fight it out. So we went to court, and now this enjoining order was there for, I think, about 3 months. For 3 months, we couldn't sell our tea. Every 14 days, the case got called, and it was extended until this interim judgment was given, the interim order was given. Finally, we were able to convince the judge that the other party has no case and that our tea is not similar to their tea, the packaging. So the courts refused to give an interim order. They said interim order cancelled. No interim order, no enjoining order. That means from now on, we can sell our tea until the case is heard and finished. At the end of the case, the courts will give a judgment, whatever. 2 days later, the other party dropped the case. They withdrew the case. The only reason they were in court was what? To prevent us from selling tea. They didn't want us in the market. Very obvious, no? When they immediately withdraw their case. Very obvious. They withdrew their case. The moment they got this stronghold they had of stopping us from selling tea was out, they withdrew. Now, so the case ended there. That was the end of that. But we suffered millions worth of loss. We had to destroy some tea because it was expiring. Right? We had additional storage costs that we had to incur because we had to recall all our products from the supermarkets. We had to do all of this during these 3 months. We suffered massive amounts of money lost, right? In addition to not being able to sell. So now we are currently countersuing them. We call it countersuing the other party. Y is now countersuing X for all the damage that was caused to us because of this fraudulent litigation. If you file a case against another party without a just cause, the other party can sue you for malicious prosecution. Malicious prosecution is where you sue without a cause. Clearly, they didn't have a cause. No, that is why they withdrew the case after the interim injunction was withdrawn. Right? So we are suing. So what I'm trying to say is these interim orders are very powerful. These interim injunctions. Final injunctions are equally powerful, but the interim ones are also very powerful. So it's very important that you present the right facts and maintain the status quo correctly until the case is heard. For that purpose, we have injunctions. So you can have declarations to stop performing the contract. You can ask for damages. You can ask for injunctions. You can ask for specific performance. Finally, there is an option called quantum meruit. These are all Latin phrases, right? Quantum meruit. Quantum meruit essentially means whatever we deserve. In addition to all of this, whatever else the judge thinks we deserve, we want to get. So you may make an application for quantum meruit also. So you will ask for specific performance, you will ask for injunction, you will ask for damage, you will ask for declaration, and then say anything else the judge thinks we should get, give us that also. Right? Quantum meruit. Quantum meruit very rarely given, but the courts may give additional remedies that we don't ask for. Sometimes we may not have asked for an injunction, the courts can give an injunction. Sometimes we may not ask for damages, the courts can give that. So it's a safety net that lawyers use to say, like, even if we don't ask for certain remedies, we want that. Okay? Then when now out of those 5, damages is there. When you ask for damages, that important question came as to how damage is calculated. Right? When you're asking for damages, the obligation is on you to show you have actually suffered the damage, right? The calculation of damages is done. There's a very complex methodology in a case called Headley versus Baxendale. Anybody interested can have a look. But Headley versus Baxendale says how is damages to be decided, right? Damages are to be decided. He says, look, you have to show that you have actually suffered the damage. You have to show that the damage is not too far-fetched. And most importantly, you have to show you have taken the necessary steps as the innocent party to reduce the loss or the damage that you may suffer. Mitigate the loss. You have to take steps to mitigate the loss. I'll take 5 minutes and then we'll have the presentation. I'll finish this off, right? Your next class is at 11, is it? Yeah, okay. To mitigate the loss, right? Mitigate the loss is this. Now, there was a case where Dr. Cabral was involved, where there was a contract for transport to be provided. That was a transport company. One company, we had a factory. We entered into a contract with this company saying, look, provide us transport for our 500 employees. So these guys had buses that were dedicated to us. They picked up the employees. All that was done. At one point, the contract was terminated. Right? We terminated the contract. They sued us saying, look, we had unlawfully terminated, and they asked for a massive amount of damages. Now, it was very difficult for us to argue that we are not responsible. But we made an argument that the quantity of damages that they were asking was too much, on the basis that they have not mitigated their loss. Now, when we terminated the contract, when we ended the contract, when we didn't perform the contract, they didn't need to keep the buses parked and waiting. They can use the buses for another contract. They should negotiate and get a new contract and put them to work. They said, look, from the date you terminated until today, the buses are still parked. He said, what are you doing? For 2 years, you're just waiting with the buses there. You can easily put them back to work and reduce the loss that you suffer. You can't wait, or you can't sit on your rights and then ask for that damages from us. So we argued on the basis that they did not mitigate the loss. So Headley versus Baxendale in its calculation says damages must be actual, must not be too remote, and you must mitigate your losses. The innocent party also has a part to play here. They must mitigate their loss. Failure to do so will result in them being liable. Clear? All right. So this is contracts. 10 points, contracts. Right? There is 2 little points that I want to talk about on contracts, which is on sale, not contracts, which is related to contracts on sale of goods and the Consumer Affairs Authority. But I think we don't have time because I got a little late today. What I will do is next week, before we start taught, I will finish those little 2 parts. Okay. That will be a tiny discussion on the end of this, and then we'll start on top. Okay. We'll stop here because I want to do the presentation. So you guys can come and do the presentation. So next week we have 2 presentations again, right? Shall we say that who's going to go first? You guys can go first. Yeah, you all will go first. You all will go at the end. Okay, cool. Let's do the presentation and then you all can take a break.
Hi, everyone, and good morning. Now, I know you must all be a little bit tired. It's Sunday morning, and you're looking forward to your break. And probably the last thing you want to do is listen to more theory. So instead, my team and I, we introduce us really quickly. Sorry about that delay, guys. So this is our team. I'm Amanda, and with me I have Varuna, Pumi, Nirmala, and Lahiru. So instead of giving you just a case theory, we'll try and tell you a story with a little bit of theory mixed in so that you learn something. So first, let me take you through our agenda. I'll be giving you a case overview. You can consider that the story summarized. And then my team members will go into detail on the case to see how the judgment was made, such as specifics on contract law theory, the offer, and the acceptance. So to get into the case, this story is about this lady, Mrs. Carlyle. Now, when you see her, you might think, she doesn't look very remarkable. But actually, she is someone who did something that most of us would probably not be brave enough to do. Sue an actual company over something so small as an inhaler. But before I get ahead of myself, let me give you some background details. So picture this. The year is 1892, and the world is on set with a global pandemic, kind of like what we are now. However, during that time, they didn't have vaccines or masks or any protections like that. So everyone was just desperately grasping for any cures they could find. That brings us to the second main character of this drama, the Carbolic Smoke Ball Company. Now, they had some very ingenious business people who saw the opportunity here and capitalized on people's fears. They invented the smoke ball, which they claimed would positively cure anyone of influenza. And they were so confident about this and their lawyers that they issued this very attractive and catchy advertisement saying that if you use their product as prescribed and you still get influenza, they will pay you £100. And as a show of good faith, they even deposited £1,000. Now, Mrs. Carlyle also saw this advertisement and she was very impressed. Who wouldn't be? It's a win-win situation. You either don't get influenza or you get £100. And in those days, that is a lot of money. So she went and bought a smoke ball and she used it as prescribed for about 2 months. But then she still got influenza. So then she thought to herself, okay, the company can't deliver on that cure. Maybe I can get my reward. And she said this to the company, but the company refused to pay, saying that this was not a serious contract. Now, this is where she becomes a true heroine and sets the precedent for future cases where ordinary people sue big corporations. Instead of thinking the company must be right, I must be wrong, this is just advertising, she got her husband to file a case against the company demanding the £100. Now, I won't get into the nitty-gritties of this because that is what my team will be doing. I'll just tell you what the judgment was. The trial judge voted in favor of Mrs. Carlyle. So the defendant, the smoke ball company, raised an appeal in the appeals court. And this too was rejected. So that raises the question, what were the very persuasive arguments made by Mrs. Carlyle's lawyer that persuaded both courts that she was right? Lahiru, why don't you get started on that by explaining what constitutes an actual serious contract?
Thank you, Amanda. before go to the case, I would like to introduce about the contract law theory. So, what is the contract? Before before go to the case, let's look what is a contract. Contract is an agreement which will be enforced by law. That means if you made an agreement, if you made an agreement, if any party breached that agreement, you can take a legal action against other party. So in Sri Lanka, the general law governing the contract law is Roman Dutch law. It is the common law of our country. And next, I would like to introduce about the type of contract. In English law, even though there are a lot of type of contract, in English law there are three main type of contract. First one is contract of record. These are the judgment of courts of law and other recognized tribunals. Second one is contract under seal. That means if two parties get into a contract with in written form with sign and seal, that contract can be described as contract under seal. It is also can be described as deed or specialty contract. Third point is simple contract. This is the most common type of contract. It can be in verbal, it can be in written, or it can be in by conduct. Under the Roman Dutch law, it is considering all the contracts as simple contract. So let's look at what are the conditions that need to exist to become a contract. First, there should be two or more parties. Then parties must intend that their agreement will lead to legal relations. Third point is contract should comply with any required statutory formalities. And fourth point is in English law, consideration required. That means consideration is something that can be value as an economic value. But in Roman Dutch law, it is not required. And for fifth point is to the parties to the legal agreement should have legal capacity. That means minors and mentally unsound people or intoxicated people cannot make agreement. Next point is agreement must be genuine. That means agreement cannot happen due to mistake, misrepresentation, duress, or undue influence. Final point is agreement should have a purpose or object which is not an illegal. That means you can't have an agreement to rob a bank because that purpose is not legal. So I would like to invite Pumi to continue the presentation with the case.
Thank you, Mr. Varuna. To form a contract, to form a contract, there must be a to form a contract, there must be an agreement between two parties. And let's here consider what is the meaning of the offer. So according to that, we should know what is the difference between the invitation to treat and offer. So the invitation to treat is an invitation to people to create an offer, and there is no legally binding. But the offer is a proposal by the person which they are willing to enter into the legally binding contract of some consideration, and the offer can be accepted by the offeree, and when it get accepted, it become an agreement. So according to the case of Carlyle versus Carbolic Smoke Ball Company, even after using the smoke ball, Mrs. Carlyle suffered from influenza. So she sued the defendant company to claim in the £100. But the defendant company argued that the advertisement was not to be taken as a serious legally binding offer. It was merely an invitation to treat. But the court dismissed the appeal and stated that there was a serious offer, and court further held that there was a fully binding contract between Mrs. Carlyle and Carbolic Smoke Ball Company, and the court held that Mrs. Carlyle was entitled to recover the damage of £100. So next, I would like to invite Mr. Nirmal to continue the presentation.
Thank you, Pumi. So after the offer, the contract needs acceptance. So in order for a contract to be binding, usually acceptance should be communicated to the offerer. But so this is the stance that the carbolic smoke ball company took in the court case against Mrs. Carlyle, that there was no communication between them, that the acceptance was done. But this case was a bit different. The advertisement set out the conditions that need to be met in order to obtain the reward. And these conditions could be considered or interpreted as the acceptance for the offer. Also, the advertisement did not specify that the acceptance should be communicated. So the court decided that the conduct and the performance of the said given conditions was a form of acceptance. The case Broadcom versus Metropolitan Railway Corporation also established that a contract can be accepted through conduct. So this was a previous case that established the conduct of a specific performance as an acceptance. After the acceptance, consideration is also another aspect that needs to be fulfilled in order for a contract to be formulated. So consideration is the benefit each party receives in exchange for what it gives up in the contract. So here, the consideration of the carbolic smoke ball company was that through the advertisement, they received revenue and sales. So this was their consideration. In the case of Mrs. Carlyle, the fact that she had to directly face the direct inconvenience of using the smoke ball 3 times per day for 2 weeks, as per the conditions in the advertisement, this was her consideration for the contract. So because of this, performance of these specific conditions constitute for the consideration in the contract. So next, I would like to invite Lahiru to give the rest of the presentation.
Thank you, Nirmala. So parallel to this condition, identify the contract, is it a unilateral or bilateral, is a very important. So let's see what is the unilateral and bilateral contracts. So any contract could be bilateral or unilateral. Bilateral contracts means that contract negotiate, there will be 2 or more parties, and both parties will have obligations. So as an example, if there are 2 parties called as A and B, A also promise things to B and also B promise things to A. In the unilateral contracts, it is not like that. If there are A or B parties, A promises things to B, but there are no obligations from B to A. Only thing as they can accept that offers terms and condition and enter the contract. In Carlyle's carbolic smoke ball case is a unilateral contract because the smoke ball company has promised to pay £100 if they are who use smoke ball if get influenza, but there are no obligation from customer. Only thing have to do is use the smoke ball and enter the contract. So identify bilateral or unilateral contracts will give the smooth process to in the court process. So now I'm going to conclude our presentation. Thank you very much for listening, and you all are welcome to ask any question if there are.
All right, that was good. Do we put these presentations up on the portal for you guys? Is that happening? Can we put that up? Can we put these presentations? Can we upload all their presentations? Then we'll have a collection of these. Can we do that? When you finish your presentations, give it to these guys so they can upload it. So everybody will have, these are the important cases. Then everybody will have all the facts, no? So we can create a Google Drive folder or something and you can put everything in, no? All right, so just give it so it will be helpful for everyone as we go along. Okay, all right, thanks everyone. I'll see you next week.